In a bid to get his client off the hook, advocate Zithulele Nxumalo argued that the evidence of the state star witness, Constable Sizwe Zungu, who placed all 5 of the accused in Phosphorus on the day that Senzo Meyiwa was killed, should be approached with caution. Nxumalo says it's riddled with contradictions and no witnesses were called to corroborate Zungu's version.
The bulk of the evidence of Zungu refers to hearsay evidence, in the sense that no witnesses were called before this court, despite him referring to those people were called before this court to corroborate the evidence of Zungu.
Nxumalo argues that there is no evidence either that Maphisa acted in common purpose.
Zungu's evidence, it must be noted, my lord, that it does not detail a plan by the accused to execute the assassination of the deceased. It does not place the accused together, or even himself, Zungu, that he overheard such a plan. Zungu's evidence does not reveal any prior agreement amongst the accused, including accused number 4, to kill the deceased. In the absence of a prior agreement to kill the deceased, it therefore becomes important to apply the 5 principles as stated in Gedde's decision. The presence at the scene. The accused must have been present at the scene of the crime where the violence was committed. There is absolutely no evidence, my lord, that accused number 4 was present at the scene of crime where the violence was being perpetrated, either circumstantial or direct, at or near the scene of crime at house number 135.
Nxumalo says this despite lead investigator Brigadier Bongani Gininda previously telling the court that accused number 4, Mthokoziseni Maphisa, had run inside the house on the day of the killing.
That there is no witness or witnesses that place accused number 4 at or near the scene of crime. The witnesses who testified viva voce before this court did not implicate accused number 4 as one of the intruders, or that at some point they, that is the intruders, after they had fled, another intruder entered the house. The assertion by Brigadier Gininda that accused number 4 entered the house must be rejected as false beyond reasonable doubt, as they do not find support from the witnesses.
And that there is no evidence that Maphisa even received any money from Kelly Khumalo, who the state says was the mastermind.
There is nothing in the bank records, my lord, that suggests that accused 4 received any proceeds from the mastermind for the killing of the deceased.
And therefore, Nxumalo says Maphisa should be acquitted.
There is no independent evidence that accused 4 participated in the murder and the subsequent robbery, or that he was part of the conspiracy to kill the deceased. The state did not prove beyond reasonable doubt the inference that he had intention to exercise possession through the actual danger, and that the actual danger had the intention to hold the firearm on behalf of the group, except what is contained in the confession statement of accused number 2. In terms of the 5 principles I've alluded to, enunciated in the State versus Gedde's decision, that is the presence at the scene, awareness of the attack, intention to make common cause, active association with the attack, intention to kill the deceased or to contribute to his death, I find none. It follows, therefore, that the state has failed to establish a prima facie case in respect of counts 4 and 5 of the indictments, and to this end, he must be acquitted. Conclusion. It ought to follow that if a prosecution is not to be commenced without that minimum of evidence, so too should it cease when the evidence finally falls below that threshold. In short, my lord, what I'm submitting in my heads of arguments is the following. that there is no evidence tendered by the state upon which this honorable court may convict accused number 4. The onus is not on the accused person to prove his innocence. It has always been the duty of the state to prove the case beyond reasonable doubt as far as 1961. It is not the duty of accused number 4 to go to the witness box and supplement the state case in any way, or incriminate, or by so doing, incriminate himself. For the foregoing, I submit that the accused that is accused number 4 be acquitted and discharged in terms of the provisions of Section 174 of Act 51 of 1977, dated at Pretoria.
Criselda Lewis, SABC News at the High Court in Pretoria.